Session number 335 of 2025, together versus Banno, Dr. Besigye and Captain Dennis.
That's true, my lord. That's true, my lord.
This is the ruling of this honorable court. We'll start with the backup ruling. Accused persons are indicted with 3 counts. Count 1 is treason. Count 2 is treason of treason. Count 3 treason of treason. Or under penalty. The accused persons were charged in Nakawa Chief Magistrate's Court on 21st February 2020. From court report, lower court, accused persons were committed to high court on 29th May 2020. Thereafter, from the lower court file number 8, 2025, I will now consider submissions made by the accused persons. In summary, A1 challenged the court's asserting that A1 wondered why there is criminal division. He submitted that this was a deliberate wrong allegation. The accused further stated that they have since filed a formal complaint with the Judicial Service Commission in removal of the trial judge from the office of the judge. A1 prayed that the original file number 8, 2025, from Nakawa, the now session number 6, be transferred to international. Issue number 2 that the trial judge is incompetent or biased, basing on the ruling made against trial judge. Anyone submitted that the trial judge is competent but not submitted that the charges that are related with or under the jurisdiction expected that the matter continues at criminal division for reason warrant ICD since the right is for bias to decide on it. Further submitted that against this petition against the trial judge, not the bar of the judge under this matter, which was brutally stated that in any case, the service commission has not brought the petition stop him from handling. In reply, the issue of identity raised by SB. The state attorney submitted that the issue can be dealt with by making an amendment for the issue. In rejoinder, the lawyers of the accused persons made submissions on behalf of the accused persons, stating that the prosecution had raised issues of law needed to be addressed by advocates. I have put into consideration all their submissions, which I will quote before. But briefly, I will summarize their submissions. Half of the number one, they are maintained on this matter. This court has no jurisdiction that the file should be transferred. Also submitted that there is an order for mutual from the power chief magistrate ordering the file of IC. File was matched and lost in modification. That the order of the was for ICD. Question is, also submitted that divisions and the processing composition ICD far from that one. Also contended that court is taking the matter, even though the division has no jurisdiction. Also stressed that the indictment from our court is clear that the accused were to be tried special that it is not right state that there was also admitted further that the offences of against the accused person they are committed cross border. This ICD by cross border crimes. In regard to competence, also submitted that fairness in the mind of the man, that justice must not only be done, but also be seen done. Also submitted that the accused persons made a complaint to the service commission for removal of the trial. Hence, the trial judge did not continue. Further, counsel also referred to the ruling in the application where this honorable court is trying to grant A1 and A2 money. Yet, in their view, at the price for money, stated that this amounted to competence or bias, which compromises this right to fair trial. In rejoinder by counsel for SB, Counsel for SG submitted that this of identity was raised in lower court, but the same was also referred to the case of the where a court of appeal passed the lower court. Counsel prayed that this court be free, but this read of the order. And now proceed. Court. One. Number one. Court has no jurisdiction. I have had the opportunity to recognize the entire lower court report. Case number 8, 2025. Case number now session number 2025. I have also looked at the history of this matter even before committal. Upon looking at the history of this matter, there are various applications arising from the same case. Case number 8. A1 and A2 filed criminal application number 1, 2025. This application for bail was arising from the Power Chief Magistrate Court, case number 8 of 2025. This application was filed on 27th February 2025. When personally, as a trial judge, I have not been this application for bail in criminal division was handled and disposed of by my sister judge, Justice Kani, on 11th April 2025, when the trial judge was A1 and A2 further filed another application for bail. This bail number was application number 282 2025. This application for bail was filed on 22nd. This bail application also arises from the same case of Nakawa, number 8 of 2025. This application was filed in the criminal division. This application for bail is still pending. The accused person, who still noticed that they filed an application for revision of criminal division. This case for revision was arising from the proceedings of the Power Court. The same criminal case of 2025. This case for revision has since been withdrawn. A1 and A2 went ahead and filed the insurance application number 299 2025. It was filed on 28 May 2025. It was an application for mandatory bail. This application was equally filed in criminal division. It was heard and disposed of by this honorable court. All these applications, my view, filed in criminal division show that the accused person and their lawyers knew that this was the right court or right division with jurisdiction grant bail, and all these applications the own voluntary counsel filed these applications arising from this criminal case of Nakawa, number 8 of 2025, now session number 5. In addition to the above finding, I have very carefully looked at the committal procedure in our chief magistrate. Upon the result, the lower court report, that is case number 8, 2025, when the chief magistrate Nakawa was committing the accused person on 29th May, court stated quote, that with the indictment, some of the case, when the accused persons are hereby committed crime. My view, criminal division is the division of high court. Also, my view that criminal division has jurisdiction to handle cases of this nature. The lower court record also shows that case number 8, 2025, was forwarded on Ikimis 27 situation. When this file was forwarded on Ikimis 27 situation, the file was officially allocated to the trial judge on 2nd July. Further, the Chief Magistrate Nakawa, according to the court report, Magistrate Nakawa wrote a forwarding letter to the Deputy Registrar of Criminal Division. This letter is dated 15th July, available in court report. This letter was forwarding the file number 8, 2025, Criminal Division. All these developments show that criminal case number 8 of 2025, now session number 635 of 2025, was properly forwarded to criminal division after committal. This court is not aware of any registration number of the same case registry. Or court is also not aware of any other forwarding letter from the lower court to the registry of ICT. This has been claimed by a lawyer to suggest that there are other documents forwarding the file of ICT. If any, there is no document provided this honorable court so that the same case number had been added to ICT. Also to mention that the accused persons are charged with offences of treason. It is treason and treason. This division, criminal division, has jurisdiction to try the same and handling other similar cases. Was my considered view that the turnaround by the accused persons alleged that the criminal division of the High Court hijacked the file from ICT and of which it lacks jurisdiction to try this matter. Mayor, after so, and the deliberate move, which I cannot at this stage. In the view of the above, I found that this file, number 8, now session number 5 of 20, and the accused person are properly before the right court. I will now go to the issue of the file that the file judge is for bias, basing on the ruling made application of mandatory bail. Hence, I will proceed to consider the issue of incompetence and bias and subsequent request for recusal. I have looked at the grounds for recusal in practice elections. And down, I have looked at other authorities for recusal and the tests those cases. Then, but I will now proceed this instant case. The basis of allegations of incompetence or bias stems from the ruling on application. That was application number 399, where it is alleged that court ignored political consideration for A1 and A2 notification denied the mandatory benefit. This is my considered view that the application of a mandatory benefit, which was considered on its own merit, based on the facts and the law relating to mandatory. The accused person cannot use the decision of the court for denial of mandatory bail to impute. In any case, down to my practice as a judicial officer, the court can deny bail today on circumstances, but grant bail at any stage of the later stage. So, denial of bail, the first time of denial of bail, doesn't mean competency or bias or that the judge will never grant. Not proper for litigants use decisions which are not in their favor. Make false allegations where parties decisions that are not in their favor, like it was the application for mandatory bail. The remedy and procedure challenging such a decision are provided for under the law. Not fair fight and allegations of competence. The accused person's father claimed that he made a complaint against the trial judge, petitioning his removal from office. This, I view, that the said complaint not use judicial service, not a bar or a scale of proceedings, or cannot be used for refusal. Whoever wants, otherwise, whoever wants to prevent a judicial officer from hearing a certain case, to simply lodge a complaint with the Judicial Service Commission, which will cause absurdity, not find any ground for refusal based on allegations of competence or bias. It should be noted that this court is a temple of justice, which upholds the constitutional principles of fair trial and natural justice, as provided for under Article 28. There is no way that this court can bypass the constitutional provision and undermine the rights of the people. Their trial. This, their trial, indeed, as submitted by lawyers, is provided under the constitution. And this court was a court. So now go to issue number 3, which was raised by this. Let's raised an issue by this. That he's not the person mentioned in the indictment. That though they have the same post number.
Moses.
We have been instructed by the accused persons to seek for a reference to the Constitutional Court. My Lord, the instructions we have emanate out of that ruling and Article 28, Sub-Article 1, and Article 44, Paragraph C. 28, Sub-Article 1, and Article 44, Paragraph C. of the Constitution. My Lord, the gist of this application is that in these proceedings, an issue requiring interpretation of Article 28(1), 44C, 28(1), and 44C has arisen. My Lord, in its ruling, the court considered that there is presently a complaint pending against it before the Judicial Service Commission. And concluded that the pendency of such a complaint is not a bar to this case proceeding, neither can it be used for recusal. My Lord, the grounds of that petition are for the Judicial Service Commission to determine they are not for determination here, but that complaint was made by A1 and A2. And is seeking the most severe outcome possible against a judicial officer. My Lord, it is seeking the removal of your Lordship. My Lord, in those circumstances, and regardless of the history of the committal proceedings, the applications, and so on, that your Lordship has observed or referred to, the question that remains, the answer, is whether this court can continue to be an independent and impartial court within the plain meaning of Article 28, Article 1. My Lord, bearing in mind that that article cannot be derogated from, the question whether in its plain meaning a court faced with the circumstances I have just described can be or even seen to be independent and impartial, particularly for purposes of trying those people who have lodged that complaint.
My Lord, the gist of this application
My Lord, the place of the right to
is
fair
that
hearing
these proceedings an issue
is
requiring
sacrosanct place.
interpretation
Hold it in the highest possible esteem. Is the only thing that stands between
Article 28(1), 44C,
absolute tyranny
28(1), and 44C
and the rights of an accused person.
has arisen. My Lord, in its ruling, the court
My
considered
Lord, there is a question we submit that has arisen. The context of Article 137,
there is presently
5 of the Constitution
a complaint pending against it.
this court is required to submit to refer
Before
That
the Judicial Service Commission.
My Lord, permit me to read
And concluded
Article 137.
that the
Fine.
tendency of such a complaint
My Lord, it provides that where any
is
question,
not a bar
Article
to this
137.5,
this case proceeding,
where any question
neither
as
can
to
it
the
be
interpretation of
used
this Constitution arises
My Lord,
any
the grounds
proceedings
of
in
that
the court of
petition
law
are for the Judicial Service Commission
other than a field court martial
to determine
the court A
they're not for determination here. But
may, if in its opinion
that complaint
the question involves a
was made
substantial
by A1 and A2.
question of law. And B,
and is seeking
shall, if any
the
party to the
most
proceeding
severe
requests it to do so,
outcome possible against a judicial officer.
we further question the Constitutional
My
Court
Lord, it is seeking the removal
for a decision.
of
My Lord,
your Lordship.
just for completion, when that referral is done,
My Lord, in those
Constitutional Court
circumstances,
guidance on the interpretation of the Constitution
and regardless of the history of the committal proceedings,
be
applications,
waited for, must be
and so on, that your Lordship has observed
before the matter
or referred to.
proceeds. But, my Lord, under the two paragraphs that I have cited, paragraph
Question
A grants this court
that
discretion.
remains the answer.
Paragraph B does not grant
Is whether this court
such a discretion and is mandatory in its terms.
can continue to be an independent and impartial
My Lord, the way that article
court
is framed,
within the plain meaning
the court in doing its work may find an issue
Article 28,
and make a reference.
sub Article 1.
But if any of the parties on whose behalf that work is being done asks it
My
to
Lord,
refer,
bearing in mind that
our submission is that the court must refer. Essentially, what remains is the framing.
the question is whether in its plain meaning the court faced with the circumstances I have just described can
My Lord, if
B.
the question is hard,
or even seem to be
the Constitution
independent
agrees that
and impartial,
Article 28(1)
particularly for purposes of trying
would
those
contravene
people who have lodged that complaint.
by proceeding in this matter.
My Lord, the place of the rights of
Cause of
fair
the matter
hearing
would be in accordance with that view.
is a sacrosanct place. We hold it in the highest
On
possible
the other
esteem.
hand, insisting to proceed with the matter,
It is the only thing that stands between absolute tyranny
the Constitutional Court finds
and the rights of an
violation
accused person.
would mean that the court is itself complicit in derogating from Article 28, 1 and 44. My Lord, I would, before I sit down, also propose the question. So that we can all be guided in its effect. So, my Lord, my proposal on the question, rather long, is whether my Lord, whether the court presided over by a judicial officer against whom complaint by the accused person in that court seeking removal of that judicial officer from office under Article 144 under Article 144 of the Constitution is pending, especially where the complaint is pending, is an independent and impartial court an independent and impartial court in accordance with the plain and ordinary meaning, in accordance with the plain and ordinary meaning of Article 28(1) and Article 44(c) and is not a derogation therefrom. Lord, the question captures the issue that has arisen. Question as framed, as proposed, or an agreeable modification of the same be referred to the Constitutional Court. I so pray.
The rest was have the credits for 10 minutes.
Yeah.
Step out. that is okay with
by proceeding in this matter. And the disposal of the matter would be in accordance with that view. On the other hand, insisting to proceed with the matter in view of that question. The Constitutional Court finds a violation. It would mean that the court is itself complicit in derogating from Article 28, 1 and 44. So, my Lord, I would, before I sit down, also propose the question. So that we can all be guided in this. My Lord, my proposal on the question rather long is whether whether the court presided over by a judicial officer against whom a complaint by the accused person in that court seeking removal of that judicial officer from office under Article 144. Under Article 144 of the Constitution, is pending, essentially where the complaint is pending, is an independent and impartial court. Is an independent and impartial court. In accordance with the plain and ordinary meaning, in accordance with the plain and ordinary meaning, Article 28(1), and Article 44(c), and is not a derogation therefrom. But the question captures the issue that has arisen, and the reason why it is now necessary to interpret Article 28(1). (28) 1 and 44. So, my Lord,
My Lord, in response to the application by 1 and 8, what they were seeking the constitutional reference, the constitutional court. My Lord, it is a submission that before any court refers any matter for constitutional reference, it must be satisfied that there is a question of law, that there is a question of law right for interpretation. Any matter that is guised under interpretation, but the actual sense of it is a violation of a human right, is not a matter that this court can refer for interpretation. This court has been extremely fair to the applicants. right from the start to date. The premise of the application is the alleged complaint to the Judicial Service Commission. My Lord, there is no copy of that complaint. But even if there was a copy of that complaint, still, if that a complaint really exists, then it is the duty of the Judicial Service Commission to serve the same to the judicial officer and in fact determine it. My Lord, that letter has not been brought, or complaint has not been brought to the attention of the prosecution. My Lord, there is no act of the judicial officer so far that so there is no act, my Lord, of the judicial officer so far that requires constitutional interpretation. My Lord, our senior colleagues are aware that they have an option of filing an application of that nature before the Constitutional Court. That petition, yes. Thank you, Senior Counsel. But as far as we know, the facts, my Lord, as they are, there's nothing worth interpreting. My Lord, we shall punish you with the authority of Serugo Ismail versus the Kampala City Council and Attorney General. In which it was stated that there must be a question of law. Otherwise, the Constitutional Court would be flooded with references. Which references, my Lord, in most cases, just like in the current matter, are intended to frustrate. My Lord,
is a submission that before any court refers any matter for constitutional reference, it must be satisfied that there is a question of law, that there is a question of law right for interpretation. Any matter that is guised under interpretation, but the actual sense of it is a violation of a human right, is not a matter that this court can refer for interpretation. This court has been extremely fair to the applicants. Right from the start to date. The premise of the application is directly compared to the Judicial Service Commission. There is no copy of that complaint. But even if there was a copy of that complaint, still, if that complaint really exists, then it is the view that it is nothing of the Judicial Service Commission, therefore to be filed. And as such, to serve the same dismissed officer, and in fact determine it. This application, I thought, if it were a civil matter, it would have been dismissed with process. So, of the judicial officer, so far, that so there is no act, my lord, of the judicial officer so far that requires constitutional interpretation. My lord, our senior colleagues are aware that they have an option of filing an application of that nature before the Constitutional Court. That petition, yes. But as far as we know, the facts, my lord, as they are, there is nothing worth interpreting. My lord, we shall punish you with the authority of Cerebral Ismail versus Kampala City Council and Attorney General.
I wish to comment on the prosecution's response and say this, that the role of a prosecutor in a court of law is to lay the judges and present all the evidence to the court for the court's evaluation, and to at all times uphold justice, so that even if there is favorable evidence that is favorable to the accused, a prosecutor ought to be able to present it to the court. And therefore, a prosecutor is not a persecutor. A prosecutor should restrict themselves to ensuring that the process is fair to all the parties, including the accused persons. It's therefore very surprising to hear my learned junior stand to oppose an application for the interpretation of the Constitution on the right to fair trial. The prosecution, just like the defense, has no role in the interpretation of the Constitution. That's the preserve of the Constitutional Court. I would urge the court to disregard the gratuitous intervention of the prosecution and restrict itself to the need for the interpretation of the Constitution as to whether, just as put clearly by my colleague, the right to fair trial has been infringed by the circumstances before the court, mainly that A1 and A2 have a petition to have your lordship removed. And I once said justice is about perception. It needs not only to be done, but to be seen to be done. I'll repeat that judges are human, and you're human, my lord. And the perception of the man on the street will it be that justice can be obtained in this court or right to fair trial has been infringed. Mine was just to comment on the prosecution. I cede to my learned colleague, Kaliba.
Lord, I'm grateful my colleague from the state, because he did not object to the fact that what we are asking for comes out of a mandatory provision, the Constitution, namely 137(5)(b). My Lord, I take it that we are in agreement with the text of the Constitution, where a party seeks a reference the court shall refer. So I'm really grateful to that concession. The text is clear. The council is comfortable with our interpretation. Lord, to the view that the court must be satisfied that a question of law has arisen, Lord, we did propose the question. It is a question of law. And again, my learned friend has not objected to that question, or that it is a question. My Lord, the trial before an impartial tribunal, or indeed one which may appear not to be impartial, is a serious, fundamental question of constitutional interpretation. If my Lord does what Article 137(5)(b) requires, if my Lord does what Article 137(5)(b) requires him to do, the Constitutional Court will, among other things, tell us what constitutes an independent and impartial court for purposes of Article 28. So we submit that there is a matter ripe, to use the words of my learned friend, ripe for interpretation. My Lord, the state has responded about the complaint before the Judicial Service Commission. And is a bit unhappy that it hasn't been served on them. I thought the complaint is not against the prosecution. Otherwise, complainants would also be acting against Article 28, but they are not. They cannot even deny its existence because the ruling of the court confirmed that did it exist. And the officers that are authorized to deal with it are dealing with it. So the attempt by the state to go against the Lordship's ruling this morning not be allowed to go unchallenged. My Lord, to the point that our clients can file a petition directly before the Constitutional Court. That is indeed true. Not just to our clients, but to any other person. However, the Constitution also provided, because that is in Article 137(1), the Constitution also provided avenues, other avenues. In 137(5). My Lord, the distinguishing factor is that the question for interpretation of the Constitution arises in proceedings like this one. So,
137(1)
so
does not use the words shall in addressing the court, as 137(5) does. And my Lord, lastly on that point, there is no bar at all. The party choosing the most expedient avenue therefore, where proceedings are going on like this, 137(5) B is the most expedient option. The prosecution may not like it, may be unhappy with it, but it's the Constitution. So, my Lord, before I sit down, the matter that has been raised today, my Lord, is not about determination of the complaint before the JSC. It is related, but the specific problem my Lord, I say this with the utmost humility, is whether a judge
who is a respondent to the complaint before the JSC can try to sit in a matter to determine the innocence of the persons complaining against that judge. Look, that's the unfortunate question. my humble request, humble prayer, that you accept to refer question that, my Lord, we spend the next few minutes refining that question if it is required. The state has made no contribution to the phrasing of the question. So now, my Lord, between the court, those seeking the question, we will find it. Otherwise, where is it referred to the format that was presented?
Senior Counsel Martha Kalua addressed you on the question of perception as opposed to actual bias. And I would like to reinforce the submission of my senior colleague with the two authorities, my Lord. First, the authority of Professor Isaac Newton Ojok. We shall present them. I'm going to give the citation. Professor Isaac Newton Ojok versus Uganda. It's criminal appeal number 33 of 1991. Where a court held this is the decision that court does not look at the mind of the judge or whosoever it may be who sits in the judicial capacity. Court does not look at the mind. It does not look to see if there was a real likelihood that he would or did in fact favor one side at the expense of the other. That's not what the court looks at. And the court looks at the impression which would be given to other people. Even if he was as impartial as could be, nevertheless, if fair-minded persons would think that in the circumstances there was a real likelihood of bias, then he should not sit. And if he does sit, his decision cannot stand.
Professor Isaac Newton Ojok. The second decision, my Lord, is Tumaini versus the Republic, 1972 East Africa Law Report,
at page 441. Tumaini versus Republic, 1972, Volume 1, East Africa. It's Volume 1, East Africa Law Report, page 441, where it was held that in considering the possibility of bias, it's not the mind of the judge which is considered, but the impression given to reasonable fair-minded, and informed observers who, having considered the relevant facts, would conclude that there was a real possibility that the court is biased. My Lord, the state here submitted that there is no act of bias on your part which has been demonstrated that requires interpretation. With due respect, that is a frivolous submission. It's immaterial here. Your state of mind or act is immaterial. What is material right now is the fact that the accused persons have dragged you to the Judicial Service Commission. That is what is material. And they are seeking orders to remove you from your office as a judicial officer. So with that scenario, my Lord, an independent observer, a fair-minded, reasonable person would definitely conclude that one cannot be impartial. It's the reason, my Lord, the proceedings of this nature are structured in such a way that they are assessors. These ones, they are not lawyers, they are laymen. These three assessors here, they are ordinary people picked from downtown. So how do the law? That's what is envisaged under the law. That will you be fair and just in deciding the fate of the accused persons? When actually they are putting it. Yes, my Lord, that's where I'm headed. That's where I'm headed, my Lord. This is the matter. My Lord, that reinforces my submission that court cannot be fair. Yeah, that reinforces my submission. These are the real issues, my Lord.
The issue before court raised and framed and proposed by Mr. Kakaya. This is the one I wanted to guide the court.
My Lord, that is the spirit and the letter of Article 28. Article 28 of the Constitution. Read it together with Article 44, which is a non-derogable right. This is the issue to be now interpreted by the Constitutional Court, my Lord. Whether indeed there is a likelihood of bias on your part under the circumstances. This is a matter to be interpreted. Not that actually you are biased. Let's distinguish the two. Not that you have demonstrated actual bias, but is there a likelihood of bias on your part under the circumstances? That's the point I was making, and the point I'm emphasizing my way. And this is what is envisaged under Article 28, when the Constitution talks about an impartial judge or court. It's about perception. That's the point I was emphasizing my way. And that cannot be determined by dishonorable court, because that's what the state was seeking, that you pronounce yourself on this matter, that whether there will be a likelihood of bias or not. It's not up to you, my Lord, now. to sit in your own matter. To the Constitutional Court for reference. The issue as to whether this court has received, or actually the state has received, a copy of the complaint or not, has been succinctly addressed and answered by Council Kalibala. But I'll add one thing, my lord. So on record, my lord, in the course of the hearing of this man, when the matter was being raised by A1 himself, attempts were made to supply a copy with a copy of that complaint. The accused person, Dr. Besigye, volunteered to submit his own copy. And the court said no. The court declined and said, no, please retain your copy. There are mechanisms court will use to get its own copy. The state was interested in it, but it was available. But they never expressed interest in it. So we retained the copy. But the fact is, my lord, what is not in dispute is that there is a complaint before the Judicial Service Commission. Judicial Service Commission. It's not in dispute. And indeed, from the record, court indicated that that matter is in existence. The court is aware of the existence of it. It's no longer in it's not a dispute at all. Finally, the option is talking about we have to file a substantive petition. Cannot be used as a bar for this court to invoke its powers to refer this question to the Constitutional Court. In the wisdom of the CA delegates who promulgated the Constitution under Article 137, these options were considered to be necessary to be enshrined in the Constitution. So all these imperatives were put into consideration when they were promulgating the Constitution. Under which circumstances do you invoke which particular provision? So in this particular case, Clause 5 of Act 137 is the most appropriate. When a matter has arisen in the course of the proceedings, what do? You seek for an adjournment to file a petition? No. The reasonable thing to do under those circumstances is to move the trial judge to forward that question for consideration by the Constitutional Court, which we are doing. So we reiterate our prayer, my Lord. I will do so.
My Lord, mine, Frederick Panga, it won't take me more than 6 minutes. Just want to respond to what I feel my colleagues did not address. My Lord, Mr. Billy Vumbuka for the state. Submitted that not every matter which is a violation of a human right amounts to a crime to the Constitution, to the Constitutional Court for interpretation. When the proceedings before you are and not for human rights enforcement. As you rightly pointed out to my senior colleague, the issues about a reference for interpretation. How, my lord, in the ruling delivered by the court, the court pronounced itself thus, that the existence of a complaint in the JSC against a judge is not a bar to prosecution. I don't think that's a general principle, because indeed the complaint may arise brought by A and yet the judicial officer is presiding over a matter against B. The issue here, my lord, is that the court would be sitting in a matter where the complainants before the JSC are the accused persons before the court against which they complain. So that, my lord, the issue before this court is whether the court can sit in a matter determining the innocence of individuals who are complaining against that same court. Yes. Yes. My lord, it's the same point, and we are saying that that question is to be judged or is to be tested in the realm of Article 28.1 and 44C. That's the issue. It's not about bias, it's about the question of a fair trial within the ambit of Article 28. Lord, that's the point for you. I wish to rest our case.
This has been here since midday. Attendant has waited from 11. Made application with several submissions. The court also needs time for all this. This can be agreed. What you are there is looking at this ruling delivered. These are the 6 or 6s. I want the convenient date to post that can enable
the trend with which the court has collaborative skills that jumps for a week. So,
Yes.
20 seconds.
I've looked at my
Most of that.
and
Most of that.
at least so this
I think since he has given 25th or 6th, why don't we take this?
come again?
You gave us 25th or
No, fifth.
5th or 6th.
Yes.
6th might be
Any day from
more.
6, I have no
Yeah.
problem. So we take 6. This one is from 6 activation still. Similar terms. 6 years ago.
Yes,
Seniors application number 28 of 2025, Annual Return Dr. Kiza Besigye and Ayita Dutale versus Uganda.
may we seek that it be mentioned on the same date?
Next one.
n'alemeramu olwasembyeyo Dr. Besigye yekennyini n'asaba ye amwegambire yasooka era Ghana n'amugaa tajja mukkiriza kwogera naye oluvannyuma bwe yamukkiriza Dr. Besigye n'amugamba ssebo nakutwala mu Judicial Service Commission ng'akwemulugunyako olw'okuba nekyekubira mu musango guno guveemu okuwa omulamuzi omulala. Ekyokubiri fayiro eno yali inagenda mu ICD yali mu International Crimes Division naye gwe n'ogiremerako yajja etya wano nva mu musango guno nfune omulamuzi omulala olwaleero bagumira wano eruyi ng'alemeramu. Ekisooka kitwebuuza Baguma yalaba ki mu fayiro eno omutta kwagala kumuwozesa ekintu ekyokuvunaanyizibwa omuntu kyalina okukola alaga nti kale kanguviimu naye omulaba agulemeddemu ate nno n'obusungu bungi mumulaba likwata jagukwatamu n'obusungu bungi. Kati kyetuvudde tugamba nti owaayi ensonga zino katuzongereyo mu Constitutional Court tumusabye nti ssebo amateeka galaga ekyetuyise perception nti public ye n'ekiraba etya era emisango mugiwulidde gyonna givuddeyo nga giga nti abalamuzi kasita bakwemulugunyaako kyoteekeddwa okutunuulira nti singa nnemera mu musango guno yo public eneekiraba etya nti ddala mbadde mwenkanya oba sibadde mwenkanya. Kati atugambye ajja kuwa lulingi ye ng'ennaku z'omwezi 6 omwezi ogujja oba ddala fayiro anagiweereza mu kkooti etaputa ssemateeka oba taagiweerezeeyo. Naye ng'ekyo era kikulaga nti alina ensonga kubanga n'olwaliro yali badde asobola okuwa lulingi ti buli kimulemesa. Olwaliro ziri ennaku z'omwezi 15 weebuuze okutuuka nga 6 okusalawo oba ddala anaaba mwenkanya oba taabe mwenkanya mu musango kimwetaagisa mwezi mulamba okusalawo ekyo. So kino kikulaga nti ddala omusango guno agulinamu personal interest. Ekitulwanyisa kuba tetujja kufuna bwenkanya wa mwami Baguma twagala genda mu kkooti etaputa ssemateeka era tulemeddeko tujja genda mu kkooti etaputa ssemateeka.
Yes.